Hello friends, welcome. Friends, today I am going to discuss a totally different topic. This is regarding the High Court judgment against Lava, where Lava is fined of a huge amount, which turns out to be in dollar terms $30 million. So if you see this amount, which is right in front of you, $30 million. Now, why Lava was fined by Delhi High Court of this amount is because Lava was selling mobile phones or equipment which contained innovation done by Ericsson. So Ericsson owned a certain innovation which was embedded into those products, and those products were sold in the market, and Lava was supposed to pay some royalty to Ericsson, which it didn't pay. And that resulted in a long drawn battle between Lava and Ericsson, and that resulted in this fine. Now friends, why I am discussing this issue with you today is because that this is a highly technical issue, and this is going to be very difficult for anybody, a layman, to understand. And my effort always has been to structure the information in such a way that even a common man understands. So I am not going to go through the judgment today. Maybe this will be a two-part video depending upon how it goes and how much time is left. So what I am going to do is I am going to take you through some basic concepts, because understanding those concepts are extremely crucial for us to be able to understand why this judgment was structured in this manner by the honorable judge, and why Lava was penalized this huge amount of $30 million, right? So whoever is interested to understand the technicalities associated with this concept of patents, concept of standard essential patents, standard bodies, smaller cerebral units, it will be a very good video for you to watch till the end, so that you understand the technicalities, what involves in this whole discourse between a licensee and a licensor, and why there are certain terminologies which are extremely important and specific to India, right? So let's go without wasting any time and try to answer these questions. The first question that I have put out is, what is a patent? Now friends, patent is a very old concept. It is nothing new. It was prevalent at the time of kings in the long back. So what happens is that when an individual in a society makes an invention is something new, right? It has to be new. It can't be, just a copy of something else, or it is just an incremental value addition to an existing innovation. That's not going to be something which is called fall under the category of inventive. So somebody has invented something, so he has got two options: either to keep that invention as a secret, or spell it out before the public and try to monetize his invention. Now, once an invention is spelled out before the public openly, then everybody can copy. So how it is going to get monetized, right? And what is the need for an invention to be spelled out in public? Because it makes the overall inventing system more robust, so that people can grow from the invention which has been made in past. Because you can't really reinvent the wheel. So if a wheel is invented, on top of it a car is created, or a bullock cart got created, on top of it horse cars got created, and then on top of it motor cars got created. Now today we have got airplanes and all kinds of system running on the wheel which got invented long back, right? So when wheel was initially invented, it should have been granted a patent, because that invention was led out to the public, so that public can build on top of it new invention. Now, once you let that information out in the public domain, don't keep it secret with you, then only way you can monetize that invention when somebody gives you a guarantee that nobody else will be able to make products, copy your invention and make products, and monetize those products in the market without paying a proportional compensation to you in form of royalty. Now you understand the point, why inventions are patented, the patent system actually helps the society to grow on a previous invention which has happened in past. So it's kind of a very good system of making the society grow and create new products, and the scientific community and the consumers and everybody gets benefited out of this system. So this system is a pretty old system. There is nothing new here which we have invented. This is a very old system. So what we have done in the modern era is that we have put a structure around it, and we have created certain acts, and we have ensured that all inventions which are made today, which are patentable, so-called patentable by patent office, are able to meet certain conditions laid out in the Patent Act. And I'll explain to you one by one in simple terms without going into any document, so that you understand what are the benchmarks which have to be met in order for an invention to be qualified to be patentable. It is important to understand that, right? Now, next question is, as we go through this presentation, you will understand each and every aspect of the patent system, right? Now, the next question is, how are patents granted? I have partially answered this question. So, if a person has made an invention, he has to make a disclosure, public disclosure, that he has made an invention. Then his invention has to be drafted. Draft means you have to basically say that what is this invention all about. So you have to draft your invention in a proper structure. Once that drafting has happened, that is submitted in the patent office. The patent office official in the patent office is going to scrutinize your draft and try to ascertain that whether your invention is patentable or not. Once it is asserted that your invention, and it is discovered that your patent is is worthy for, your invention is worthy for patenting, they will grant you a patent. As simple as that. Now, there is an important point about this which everybody should understand. The patent system is geographical in nature. For example, if I as an individual make an invention in India, and I go to Indian Patent Office and seek a patent for my invention, then Indian Patent Office, when it grants me a patent for that invention, it is going to be applicable only within the Indian jurisdiction. You can't simply go and sell the product in the US market and expect that you will get compensated for that product that you have invented and got a patent in India. It is not going to happen. So in order for your product to be globally sold, you have to seek patent in all jurisdictions. Means you have to file in every jurisdiction, in every patent office, wherever there is a market for that product, to get compensated. Otherwise, you will not get compensated. So this important fact has to be considered in mind. For example, if you look at the Ericsson case, Ericsson is fighting Lava for Lava's phone being sold in India. Okay. So if Ericsson had not taken patents and applied for patents of grant of patents in India, then this case would have become a null and void case, right? Unless and until Lava exported their equipment to other parts, other phones which are made with Ericsson's invention to other parts of the world, and got profited from it. Right? So then Ericsson can say that, okay, in US you have violated my patent because you are selling my phones in US or any other parts of the country where I have taken a patent and I have a protection of that invention within the jurisdiction of that particular market. You got it now? This is a very important concept, by the way. So in order for you to get compensated and get the protection of the Indian Patent Act, you have to register or file your patent in India. Otherwise, you will not get. Okay. Now comes a very important section called Section 3K of the Patent Act. So if you look at this, the third question, Section 3K. Now, why I am bringing out this section? Because there are many sections in the Patent Act. The reason I am not talking about other sections are because it will make the video very complicated. Now, this section is actually very important section for India. Now you know that Indians are very much forward in software products because they actually have a history of software skills, and today if you look at the service sector and the remuneration that we are getting from the point of view of dollars which are flowing from outside in India, service sector, software service sector plays a very important role. There is a huge amount of inflow of dollars on account of export of services in software sector. So software is a very important aspect of India's overall service export. Now that is why what India has done is India has ensured that software, computer programs per se is not patentable. There are jurisdictions in, like for example, US, where anything under the sun can be patentable. Even an algorithm, maybe algorithm no, but computer programs are patentable. Okay, but India does not allow computer products as patentable. And there is one more important aspect to it. Computer programs are not patentable, and even if you have a specific program which is falling under the category of patent, it has to have a technical effect if it is running on a generic hardware, or it has to be a specific hardware. It's important for you to understand this. Let's say if you have a program running on a computer, simple computer, which is a Mac or a PC, and it does not result in a specific technical effect, right, which can be called as an invention, technical effect which can be called an invention, then your product is not patentable. For example, mobile phone can be considered as a generic computer, right? And if suppose there is a software code which is embedded into the mobile phone which is performing a certain function, and that function is a generic function and does not result in any technical effect. When I say technical effect, let me explain what I mean by technical effect. For example, if there is an algorithm or a code running on the mobile phone which is making the mobile phone use spectrum efficiently, right? So that's a technical effect, which is actually a invention. Now spectrum can be inefficiently used or efficiently used, right? Now if you develop a phone of a code which is running on the same generic computer but resulting in a technical effect which is much more impactful and deriving value, that is patentable. But not a simple app on the mobile phone is not patentable, because it is not resulting in any technical effect related to that product. Now you get it. So that is how, the section 3K is very important, and therefore India does not allow computer program to be patentable. Now let's come to the other important point, which is called standard body. Now what is standard body, right? And why do you need a standard body? It's very important question. Now if you look at, let me give you, an example of mobile telephony. It's important because there could be other standard body, but this is my area of expertise, so let's talk about mobile telephony. Now how mobile phones are made? Mobile phones are actually made through a conglomeration or a group of people who work within a standard body. Now let me ask you this question. Anybody who is watching this video will ask a simple question, then what is the need for a standard body? Why there is a need for a standard body? The reason there is a need for a standard body is because if everybody made a unique mobile phone for a specific country or a specific geography, then those mobile phones are not going to interwork with each other. You cannot roam, right? Your mobile phone will become unique to that particular geography. It is not going to scale. So an iPhone made in US cannot be sold in India, right? Because then Indian network is going to be completely different. So in order to ensure that the equipment scales across the world and it can work in any network, and it has economies of scale, because these products are extremely costly to develop. There are a lot of R&D which goes in. There are a lot of testing which you have to require. And then there are a lot of NRE cost which goes into those products. So it has to be amortized over a larger volume. And that is not possible unless there is a group of people who collaborate, because there will be various manufacturers, technology providers, all part of the standard body, and everybody will contribute their invention, and that invention will finally get translated into a product, right? And that product is going to keep on improving. They'll keep on improving, but it has to be a consensus basis. You can't simply say that it is my standard and I'm going to work with my standard. Then you will become an island. Right? Let's say if India decides to have its own standard, then India will become an island, and India's phones which are going to work in this geography will become very costly, and therefore the market will not be able to reap the benefit of cheaper devices, and rural areas and other people who can't afford will not be able to purchase phones, right? So that's the reason why you have standard body. Now, why there is a need for an IPR policy in a standard body, which is very important, which is the next question which I am trying to answer. What is the need for an IPR policy for a standard body? Okay. Now, the problem is the following. When you create a standard, there are certain patents which are essential in nature. Essential means that you can't circumvent them. Those patents are unique, and without them you cannot create a standard. Now, standard is important to understand. Standard is not for a product. It's very, very important. People get confused about standard. A mobile phone which you buy is not all the standard, or all that it is part of the standard do not read into the mobile phone. It reads into the complete system, which includes the base station, the core network, the RF link, everything. So when there is a mobile phone working in a mobile network, the standard will define the whole system end to end. It's very, very important for you to understand that. That is one important distinction. Second important fact is that when you are contributing patents, there are certain patents within that network or standard which is reading into the full network are essential in nature, means those cannot be circumvented. Now let's say if I am making an innovation and I go to the standard body and say that this is my patent, please accept this as a part of the standard. The committee is going to evaluate and see that whether this is really important for that product to be, or this network to be created or to be developed. So if they consider that as an important invention, absolutely essential, cannot be circumvented, then what happens is that they lock that patent into the standard. So what happens is that once the product gets created, your patent gets locked into the standard. Therefore, anybody who is trying to manufacture that product has no way anything else other than paying you royalty. So you can monopolize now. You can say that, look, my patent is now part of the standard. You have to pay me some X, and Y, Z royalty, because there is no way that guy will be able to circumvent your patent, your invention. So therefore, when a standard body is working on a standard, it is essential that whoever is participating in the standard body has to make a declaration in advance that whatever patents invention which goes as a part of the standard, if it goes as a part of the standard, those inventions are going to be licensed in a fair, reasonable and non-discriminatory manner. That is part of the IPR policy. So that's the reason why there is an IPR policy which is essential for the part of the standard. Otherwise there is no need. But because standard body is only concerned about essential patents, not non-essential. There could be non-essential. Non-essential means those patents can be circumvented. You can have another option to meet a certain requirements or a certain feature of the mobile phone. You don't have to follow somebody else's invention which he doesn't want to license. You can have circumvent. But if there are essential patents, you cannot do so, right? That is why there is an IPR policy. Now, there is another important concept which is very important, which is significantly important, which is called whether these SEPs, the so-called standard essential patents, are they verified in advance by the standard body? Standard body, when you look at the HC IPR policy, you will find that there is a clear-cut, direction to the participants of the standard body that they have to declare their SEPs in advance. Even if they consider a certain invention as an SEP, means that you can't really make a declaration later after your invention has become part of the standard. That is not possible. So what happens is that people who participate in the standard process sometimes over declare. They declare in advance, even if there is an iota of a possibility that their patents may not be standard essential patent. And standard bodies do not in any way investigate whether their patent is a standard essential patent or a non-standard. They just basically go by the declaration. So most of the time people have to over declare. It's important that you understand they don't over declare for the sake of over declaration, because If they don't, and if that patent turns out to be a standard essential patent, then it becomes a problem, because then people say, oh, this was a non-disclosure. Then you will never be able to exploit the benefit of that invention which goes into the standard. Okay, so that is important to understand that, right? So therefore, if somebody claims that I have got 100 standard essential patents, you have to take it with a pinch of salt, because those standard essential patents have not been verified. It may turn out that maximum numbers of patents which have been called out as SEPs may not be SEPs. Okay, right? So that is important. Now, how do you decide royalty rate? So we have talked about non-standard essential patent, that's fine. How do you decide royalty rates? Now, royalty rates can be decided based on two ways. One is that you can actually have a royalty rate on your own for non-standard essential patents which are non-regulated by the standard body's IPR policy. You can have whatever rates for your non-standard essential patent. However, for standard essential patent, it is important for you to understand that these has to be fair, reasonable and non-discriminatory. You can't really just go and have any rate to anybody. So that FRAND by definition is not defined by the IPR policy as such, but when you make an offer of license, it has to be comparable to an existing license which you have already offered. You can't simply go and give a different terms to a particular licensee, a prospective licensee, which are similar in nature to an existing licensee which is already using your patent and offering you a certain royalty rate. You can't have two different rates for similar licensees. It's important. That is what is called FRAND. But if there are dissimilar conditions, volumes are different or something else is different, then you can have different licensing terms and conditions, but it has to be fair and reasonable. And if somebody challenges you that it is not reasonable, then he can challenge those non-reasonability, and even it can go to the court of law, and court can basically decide whether it is a fair, reasonable or non-discriminatory or not, right? Now, it is important also to understand that when royalty rates are decided, at the time when the license negotiation is going on, at that moment of time, the opportunity exists for both the licensee as well as the licensor to evaluate the quality of patents, because the quality of patents have not been investigated at the time when the patents were offered in the standard development body, and some of the patents which basically were declared may turn out to be non-essential. Okay, so at that time you can negotiate, and that is why when you are negotiating, the whole process of negotiation is extremely important. You cannot be sitting there and sleeping and say that I just take whatever the other party is giving me. You have to be technically sound. You have to investigate each and every patent which are being offered by the licensor for licensing and for seeking royalty. You have to evaluate the quality. You have to basically check essentiality, everything. So this is a very cumbersome process, by the way. It can't be easily undertaken. For you need technical people to be involved in the negotiation. So that negotiation has to be very, very crucial to make sure that you get a good deal. Okay, so you have to be empowered. You can't be having no knowledge about this subject. Okay, then there is a very important concept called smallest sellable unit. Now this has been a matter of debate for a long period of time. Now those people who don't want to pay royalty, and they are extremely aggrieved by those people who are holding these SEPs and seeking royalties, they continuously keep on making an argument that royalties should be paid not on the price of the end handset, because that's a norm. Industry norm is that when you are selling a handset, the royalty rate is a percentage rate of the handset price. Okay, they are saying that because handset price are typically higher than chip is the smallest sellable unit they consider. So chip is going to be a price which will be much lower than the price of the handset. They are saying that instead of charging royalty at the handset rate, it should be charged at the chip rate, right? Whatever percentage that you decide, so that the royalty outflow can be minimized. But there is a problem here. As I explained to you, that when you define a standard, the invention do not just read into the chip. It's a system level invention. So whatever value that emanates out of the invention can be reflected only when the whole network gets actually actuated, not just the chip. because only the chip, reading the invention into the chip sometimes is not possible because of spectrum efficiency. There are many other issues. Because of that aspect, it is impossible to basically give a licensing on an SUC basis, smaller sellable unit basis, because all the inventions are not read only into the chip. It is basically end to end throughout the network, right? So that's a very important point, and therefore this smaller sellable unit argument has been rejected by many courts, including this particular court, the current judgment. When I speak about this judgment in the next video, I will talk about this. So I've rejected this because this is not possible to be implemented, because it not unlocks the full value. Now the question could be, then why at the handset level? Why not at the at the BTS level or any other level? It is actually has become a norm. Handset is, executing royalty at the handset level is much more easy, and it has become an industry norm. No other reason, right? So generally people are much more comfortable charging royalty at the handset level. Even if you are charging royalty at the handset level, there are certain invention which actually goes beyond the handset level and reads into maybe the base station or any other part of the system. Okay. Now that's the other part. Then what is portfolio licensing? What do you mean by portfolio licensing? Now, whenever there is an invention which actually happens, the invention is of a particular patent, and those patents can be multiple in nature. Some SCPs, some non-SCPs, there could be multiple such patents. Now, what happens is that when you are offering a license to a licensee, you don't offer licensing on a patent basis. You say that, look, I have a portfolio of certain patents and I'm going to give you a certain rate for the full portfolio, which may include both SCPs as well as non-SCPs. And they do so that it becomes a little bit of efficient. Doing it on a patent to patent basis will make the system very, very complex and, very difficult to manage. So you do a portfolio licensing. The another advantage of doing a portfolio licensing is that when you do portfolio licensing, then what happens is that any new invention which you do as a part of the daily routine of developing the product, they become part of the portfolio automatically. You don't change your licensing and royalty rate for any new invention which goes into the portfolio. So it kind of creates a win-win situation for both the licensee as well as the licensor. It's easy to manage, and the licensee keeps on getting new invention free of cost, because typically a license is for a longer duration. Then what is good faith? I've already spoken about FRAND terms. Now what is good faith negotiation? Good faith negotiation means that when two parties are negotiating with each other for a license, both parties should be willing. The party who is actually a licensor should be willing to give license, right? And other party should be willing to take license. It should not happen that the negotiation becomes just a tool for hold out and hold up. It's a very important concept. Hold up means the licensor is not willing to give license, and it's basically holding those patents up to charge excessive rate from the licensee. And hold out means the licensee is not willing to take license and he wants to sell the products without paying any royalty to the licensor. Okay, so that is called that results in an unwilling licensee, by the way. Then we have royalty stacking. Royalty stacking is what? Royalty stacking is that ensuring that your portfolio of patents continue to remain valuable by keep adding useless patents on top of it, or doing innovation which is actually not of no value. Some of the patents got exhausted, because whenever a patent is granted, this is basically for a duration of time, maybe 20 years. It is not granted indefinitely. Now some of the patents actually already expired. Now your portfolio might have got weakened, so you may have unnecessary patents in part of the portfolio in order for you to charge licensing. That is called royalty stacking. And then we have got legal remedies of injunction when it is applied. When the court finds that a licensor is trying to license a licensee and the licensee is an unwilling licensee, then in order to ensure that there are no economic harm done to the licensor, it grants an injunction. Injunction is a mechanism to ensure that both the licensee and the licensor have equal leverage. Because if you look at the situation like this, licensor has already declared the patents, clearly advertised it, and it is all in the public domain. He virtually has no leverage, right, to a person who is extracting his invention and selling the products and is not willing to pay any royalty. Unless there is a clear-cut leverage that, if the negotiation does not happen in good faith, there is a possibility of an injunction, then why would a licensee, a prospective licensee, even negotiate in good faith, right? So that is the reason why there is always going to be an option for injunction, but injunctions are sparingly granted unless and until you can demonstrate in the court of law that you actually tried to give a license in good faith. And if you have not, and if you are trying to basically hold in a hold up situation, trying to extract maximum value of your patents, then the court might not grant you an injunction. So I hope that you probably understand. It went into a 30-minute video, but it is important to understand this concept in order to understand what the Lava and the Ericsson judgment would be all about, and I'll discuss this in the next video. Thank you for your time, and I'll come back in the next video with the judgment.